That's it, sir. Thank you.
Okay. All right. All right. All right. Good. All right. All right. I'll get that out of there. Okay. Cool. So, this is being recorded, guys. When this is done, I will have it on. I will have it on the Facebook group. I'll have it on the YouTube channel and all that shit too. All right. Uh, Sarah cannot be on this one. Sarah's at a funeral, but she's very happy about this class going and reviewing docs with everyone. So I know some of you are, I'm going to skim through some of them because everyone's familiar with them, but then I'll touch on a couple key points, especially with some of the last changes over the last year, which is crazy that actually the changes have been a year in the making. And somehow people are still in real estate. Crazy, isn't it? So, all right, start with the
So real
CIS.
quick, Mark, just so you know, I'm going to monitor the chat box so you can run through this. If anyone has questions while they're going through, just feel free to pop them over there.
All right, sounds good. Thank you very much. All
Mhm.
right. CIS, again, required. This is a required doc when you're doing a packet with buyer or seller. We're starting out on the listing side. You guys understand the agency agreements that are here, agency relationships. This is the disclosure piece. And I do have it highlighted down here that when you're reviewing it with your client, right here, the statement is not a contract and is provided for informational purposes only, just like the as is clauses y'all put in your contracts. Informational purposes only. Hang me. So the key change to this one was adding designated agent. And guys, any questions that you have through this, please pop them away and fire away as we go. Don't wait till the end with this. Okay. There's been a couple, I'm gonna say a couple. There's certainly been questions on designated agent and how that works. Everyone understands dual agency, a disclosed dual agency. That's when the brokerage has the buyer and seller for the same transaction. And with dual agency, each party loses a piece of the relationship where you really can't negotiate anything and you become an intermediary. So add in designated agency in the Jersey. PA had it, but Jersey put it in a year ago. So as a designated agent, so let's just say George, you have the listing, and Mark D, you bring in the buyer. If the clients want to choose for designated agency, they can certainly choose to have that. And in that case, then that way, George, you are a designated agent for your seller. Mark, you're designated agent for your buyer, and nobody loses anything of the relationship. No one loses any negotiating power, and it's just like acting as a seller's agent and acting as a buyer's agent. The only difference is that the brokerage is a dual agent. And as the broker of record, I have to oversee that transaction as a dual agent. But George, you represent your client 100%. Mark D, you represent your client 100%. Everyone good on that?
Quick question, Mark.
Yep.
Um, so should that should essentially be signed with every client? That's allowing them to. So in that scenario, but I didn't know we were going to go see George's listing. So with every client, that should essentially be signed so that they can have proper representation on a brokerage listing.
It doesn't
My
necessarily need to be signed when you're signing the listing docs because you got to understand that, Mark, if it's your listing and you do an open house and a buyer comes in, you're a dual agent. And then in discussions with them, if they do not want dual agency and they want designated agency, then you can bring in the form as far as the consent to designated agency because at that point is when there has to be a designated agent assigned. So when you look, and I'll go through this in two more forms, but the designated agent form has a spot in there for designated agent to be put into that. And if you're doing it when you're listing the property, you don't know who a designated agent may be. Does that make
Perfect.
sense?
Okay. Yeah. So for the listing side, it would be upon it being needed,
Correct.
and then you would fill out appropriately. For a buyer side, it's not needed. Perfect.
That comes into play if the opportunity arises and that's what your client wants. Okay. So I'll go down to the consent for dual agency. This form has to be signed. Go in there every time, listing appointment, and on the buyer side too, the consent to dual agency. Okay. If again, you explain dual agency to them, and if they consent to that and they want that and say, sure, I'm okay with you being a dual agent, great, no problem. They sign this, there's the consent there. If they flat out say, I don't want you to be a dual agent, I will take designated agency. Then you can bring in the designated agency form and have them sign the designated agency form. And you can put in down here as far as the name of the licensee to designate a TBD. and put someone else in there. And then it'll be up to you that you find a designated agent in the office. You can contact George, you can contact Tim and say, hey, look, I had the seller, I got a buyer for the place too. They don't want dual agency. Can you step in and be the designated agent? I have the buyer for it. Kick me 25% referral and go to town. Make sense?
Yes, sir.
Okay.
Perfect. Thanks.
All right. So back to the dual agency again, get that signed when you're getting the um, full listing packet done and have them sign your name, licensee, brokerage, and your name is down there as far as the salesperson as well. Okay. Then again to the designated agency, the designated agent right here. Okay. Seller and buyer can be represented by a designated agent from the same brokerage firm, and then dual agency does not come into play. Each designated agent right here has legal obligations called fiduciary duties to the party the agent represents and must act in the best interest of that party throughout the real estate transaction. A seller's designated agent has a duty to advocate and conduct negotiations on behalf of the seller. Buyer's designated agent has a duty to advocate and conduct negotiations on behalf of the buyer. That's the key difference because as a dual agent, you cannot conduct negotiations on behalf of one party or the other. You have to be the intermediary at that point as a dual agent. Okay. That's the change with designated agency. Good. Okay. Moving along. All right. So listing agreement. I'm gonna go through this. I'll whip through some of it and touch on a couple of the key points here. So in some of the listing agreements that we see where they put in the address, this address right here is the owner's address where they live, which is not necessarily all the time the property that you're actually listing. So this part here is the the address where the seller actually lives, okay? And then down here, this highlighted part is going to be the address of the actual property that you are listing, okay? Does that make sense, guys? Okay. And then down here, as far as the town that it's in, the county, lot, and block number. Okay. Down here with the agency disclosure, again, you have gone through everything with that client as far as dual agency or designated agency. And if they flat out say they do not want dual agency, they want designated agency, then just go ahead and check off the appropriate box here. Term, you need to have a start date. Yeah.
Can we just emphasize, go back up to this one, that we should always be checking off exclusive broker, not the non-exclusive broker? And does everyone understand the difference between that? Okay, so it should always be, you should always check off that you're the exclusive broker because you don't want any other party coming in and taking your listings away.
This right here, guys, what she's talking about. Okay. We do not do non-exclusive listings. The only place that's really doing non-exclusive listings are seasonal rentals down the shore. Okay. But when you're listing property, it's always exclusive broker. Thanks, Heather. Okay. Term, start and end date. You need a start and end date and cannot be any longer than 12 months in the state of New Jersey. Don't go in and do a 2-year listing contract. Can't do it. Okay. You need a start date and an end date for the contract to be in effect. Listing price or lease price, again, if you're going to lease the property, but listing price will be here. And right here, guys, this is crucial. So landlord agrees that the listing price set forth in A and or B may be changed only by written instruction. You cannot go in and change the list price, drop the list price without having something in writing. I have seen it plenty of times before. Not saying from you guys, but there are plenty of times, and Heather could probably attest this being in the business for a while, that an agent will go in and knock the price down by $1 or $10 or something like that to try and recirculate it back into people's auto drips in MLS. Don't do that. Get something in writing every single time. For marketing, this is where you're going to, if you're going to list the property in multiple MLSs, you need to add what the additional MLSs are here, whether if it's going to be South Jersey Regional Shore, Ocean County, Mercer County, Garden State MLS, wherever it may be. If you're going to put it in another MLS, you have to put what that MLS is here. If there's any questions on what MLSs we belong to multiple ones. Please check with Sarah on that because I don't remember how many MLSs we're a part of. I know I just pay the bills to a lot of MLSs. Okay. Go check with her. This right here is only if this is going to be an office exclusive. Okay. And you guys can ask questions on office exclusives, whether positive or negative, but this section here is only going to be filled out if it is an office exclusive listing, meaning that it is not going to be marketed or distributed in any other marketing medium other than just internally into this office. Okay. Here,
Just a reminder on that one too, sorry. If you're
Mhm.
sending these out via dot loop to your clients, please unassign that, because if it's not, it shouldn't be, only if it's a, it's automatically checked off for some reason in dot loop. I'll talk to Sarah about maybe getting that auto in there, but it'll automatically put your seller's initial in there.
Mhm. Thank you, Heather.
Mhm.
Authorizations. You're going to check off whatever applies here. Okay. If the seller authorized to list the property in MLS, property marked on the internet, yes, check that off. That applies. Market the property is coming soon. This right here is the date. If you are doing coming soon, this is the date it's going to go live to be able to show the property. Okay. Status of listing shall be changed to active on whatever date that you put in here. And again, one of the laws that change, one of the regulations that change is that this is an unlimited amount of time now. It is no longer 21 days. Okay. If they choose to put a for sale sign on the property, sometimes people don't want it there. They don't want people to know they're moving, divorce case, some shit like that. But you would check that off here. Conduct open houses, which I highly, highly, highly advise doing open houses. And guys, you can see in the Facebook, and I know that Alexandria Lynch put a post in there today that she's available for open houses this weekend. Get open houses done at your properties, guys. You need as much traffic as you can possibly get. The market has shifted, it has changed. Listing inventory is going up, so you need to gain yourself any edge that you can in this marketplace. Get as many opens done as you can. And if you're looking to pick up business, get as many opens done as you can. I'm telling you that people doing open houses are picking up buyers. Yes, 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 picking up buyers. So get out there and do the opens. Okay. Disclose to MLS participants, subscribers, license appraisers, any buyer closing costs or concessions if we're going to do that. Photographs, we're going to have photographs or videos taken of the property. Check off here if you're allowing the agent to go in and do it. Again, there has to be permission from the seller. So if the seller is allowing or agreeing that to happen for a buyer's agent to go in, do pictures, do a video, make sure you check that off. And to put a lockbox on the property as well. Okay? Commissioner broker, I'm sure you guys want to go over this part. Okay? So, exclusive agreement. The exclusive agreement of the property is sold by broker, any cooperating broker, seller, landlord, or any other person or entity. If the property is subject of an offer under contract during the term of this agreement, seller, landlord shall pay a broker commission of. This is the commission here that you are charging. Okay? Whatever you are charging is what is going to go here. Okay? If you're doing 3%, 4%, 5%, 6%. That is the commission that's going here on the exclusive. Here again, I have checked off, we do not, or written in here, we do not do non-exclusive agreements. Okay? Do not do non-exclusive. Okay? The other part here, regardless if this is an exclusive or non-exclusive agreement, seller is authorized broker to share a commission with cooperating sub-agents, buyer's agents, and or I'm sorry, does not authorize him to offer a commission to cooperating sub-agent, buyer's agent, or transaction broker in this agreement, and the buyer is not represented by or working with a sub-agent, buyer's agent, or transaction broker, seller shall pay broker a total commission of, that's X, okay? In consideration of the additional work that will have to be undertaken by broker, okay? So if someone's going to come in not represented, and then you're going to kick in and represent them, or you're going to do extra work for them, if that client doesn't want to be represented, and you're going to add and charge additional commission, right here is where you would drop it. Okay? Same thing for the lease. Purchased by tenant. Please, please, if you're doing a lease, always put something in here. If during such tenancy, tenant at any time purchase the property, sell land, or pay broker a commission of. You need to put something in here, guys. I have been involved, say been involved, but I've had agents come to me where they were involved in a transaction where they leased the property, buyer, that tenant bought the property, and they did not have anything in here, and they were asking for a commission. Okay, you were not due a commission if you were doing a lease, tenant rents the property, and they buy the property after a year or 10 months, whatever it may be. If you don't put anything in here, you are not due a commission. Okay?
Hey, Mark, can you go back up to the previous section?
Mhm.
So when we're talking about number 3, section A,
Yep.
that is the additional or the total consideration? So
That is
for
the-
it, so God,
Good. You finish question.
yeah. So in A1, that is the total commission, correct?
That's what you're charging. Correct.
Yep. And then in section 3, if you're charging the same thing no matter what, that would
It will mirror this.
it'll mirror it. And then if
Correct.
there's an additional commission to what's in one, that would just be,
Correct. So let's just say you're doing 3% up here and you add in another 1 or 2% here. Okay. But if you're doing a
okay,
five,
got
if you're doing a 5% listing total or 6% listing total or 7% listing total, and I give those three options so no one sits there and sees this on YouTube and tries to sue me for price fixing, scumbags. But if
yep.
you do that and your total is here, then it says right here, pay broker total commission of and whatever that is. Make sense?
Yes. All right. Got it. All right. Perfect. We're
Okay.
good. Thanks.
Okay. Got it. All right. Moving on down. All right. Right here. Okay. Protection period, exclusive agreement. This is the protection period, which there's a couple specific points in here. If it's an exclusive agreement, brokers paid a commission, so forth, blah, blah, blah. If the property becomes subject to a written agreement, blah, 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 or the property sold, conveyed, rented, optioned, or in any way, or transferred within X amount of days after the termination or expiration of this agreement to a buyer or tenant. So understand that if you list the property and it expires, and the property is sold within 30 days after termination of the agreement, or 40 days or 60 days, whatever you put in here, you're still going to be due a commission if and only if, right here, provided that broker has provided seller, landlord with a written notice, which includes the names of such prospective buyers, tenants within 10 days after the termination or expiration of the agreement. Okay? This has to happen. If this does not happen, if you don't give the seller written notice about these 10 buyers came into the property while it was listed, if you don't do that and one of those buyers purchased the property, you are not due a commission. Okay. In addition, right here, however, whether if this is an exclusive or non-exclusive agreement, seller should not be obligated to pay such commission if a bona fide listing agreement is entered into during the protection period with another licensed real estate broker and a sale, lease, or exchange of the property is made through that broker. Okay, so that's protection period. This protection period here is to protect brokers from a seller trying to sidestep them and not pay a commission at all. But if that seller lists with another agent 2 days after the fact, then all bets are off. Okay.
Is there a best practice here to obtain those buyer names from the other agents?
You're not going to get buyer names from other agents. Okay. I mean, you can connect with a buyer, especially if someone put an offer in on a property. It really is more designed for buyers that you showed the property to.
Okay.
Okay. Makes sense.
Yeah. So I guess even putting in these are the agents that show that, if you're providing the list and you put in the agents' names and dates.
You're going to have a hard pressed time if it's a
Yeah.
buyer that an agent brought in. And that's why you see here names of such prospective buyers slash tenants
Yeah.
and not agents.
Okay.
Okay. All right. Concessions down here. If the seller is going to offer a concession, we talked in the beginning, you're going to offer a concession, whether it be for we're going to pay X amount of dollars towards closing costs for carpet, whatever it is, put that in here. So I was going to offer a concession. You can enter what that concession is for here. And that is not, they're going to pay a 3% seller concession to take care of the buyer's commission. Don't put that there. Okay. All right. Other part here, commission cooperating broker. This is some of the stuff that's all changed, guys, with the new regulations. We'll get into this. This whole stuff up here is all disclosures that have to be, that all part of the agreements are all charged now and changed. Hi, Kelly. All right. On this listing, the broker is offering commission split of whatever is negotiated, whatever you speak to your client about. If you speak to the seller and you do have the conversation with them about offering commission to a co-op broker, that's what's going to be here, minus zero. We are not one of the scumbag brokers that takes money from the agent's commission. We don't do that because this right here is money that gets taken from the agent's commission. If you want to charge some kind of admin fee on top of whatever commission charging, that's fine. That's your call, your business. I don't have a problem with that. Don't take money from an agent's commission. I don't like that. Okay. If you feel that this may result in your property receiving less than maximum exposure to buyers or tenants, you should discuss those concerns with the listing salesperson or their supervising broker. That's the discussion with them. Okay. You need to have that discussion with them. Excuse me, on offering co-op splits. There are people that have read about and heard about the lawsuits and will ask about that. Okay. But you got to have that discussion with them. Guys, when I tell you there's not a whole lot that's changed as far as commissions being offered by Sellers, there's not a whole lot that's changed because they understand the marketplace. Also understand it's a little more challenging for buyers to come up with extra money for that. But you got to have that discussion with them here. Okay. So as far as the consent to commission splits right here, so let authorized broker offer commission split to cooperating brokers. And again, this you have to factor this in with your commission that you're putting in up here. Okay. So you got to understand the contract. Let's just say for numbers sake, you put 3% in here, total commission. Okay, 3%. And then you come down here and you offer a 2% commission out to another broker, you get one. Okay. The numbers have to add up and the math has to math. Okay. So consent to commission list, the offer line is what is the commission that's being paid to the co-op broker. Okay. And you see, I've checked off here sub agent, buyer broker, and nothing to a transaction broker. I've never offered anything to a transaction broker. And I would not recommend it either. Sub agent, buyer broker, yes. Again, sub agency really should not be in play anymore. And with all the laws that have changed, the state should have changed this contract, but you might wait on another 17 years for the state to actually do that and get it right. Okay. But sub agent, yes. Buyer broker, yes. And then what that offer is going to be here. Okay.
Hey, Mark, since I'm not reversed in what the sub agent would be, is there any potential there for a sub agent and a buyer's broker to be involved and for that to get?
So sub agent shouldn't be involved anymore because a sub agent is just a buyer working with a buyer without a buyer agency contract.
Oh, okay, perfect.
That's all it is. So it should never be in place anymore, and that should have been removed from this. But that's the state, you know. So I don't know tell you about the
Got it.
state. Okay. Consent to disclose authorized commission splits to cooperating brokers. Okay, your two check boxes. Seller and land authorized broker to disclose the authorized commission split to cooperating broker, representing working with potential buyers, or seller does not authorize broker to disclose the authorized commission split to cooperating brokers, representing working with potential buyers, and instructs broker to do as follows. Okay, because you're going to have two different philosophies on this. You absolutely will. And I'm not saying one is right, one is wrong. You have to see what works best for you, what works best for your seller as well. Okay. Some people say, look, just disclose it. You get a call from the agent. Yes, disclose it. Others will say, don't disclose it because it may be selling your seller short. It may cost them some money based on what the buyer agency contract is that the agent has with the buyer. If a buyer agent has a contract with a buyer to get paid a 2% commission and you're offering 3% as far as a co-op, and that's being disclosed, again, it could take some money out of seller's pocket. Okay, so it depends on what it is you're going to do. And I think I have some notes. I got some notes down here somewhere. Let me see. Okay, it's right here. Section 7A and B is what we're just on. The seller is not offering a commission to a cooperating broker in this agreement. However, the seller is open to negotiating commission to be paid to a cooperating broker based on the terms of the buyer's offer. You can put anything that you want into the contract. So you're saying something specific in here, saying that the seller is not going to pay a commission as far as a co-op split, but they're open to it. So as far as this goes, nope, they're not offering anything. So if I get a call from an agent, hey, is there a commission being offered? I'm telling you right now that there's no commission being offered in the listing contract. However, seller is open to negotiating. Put in the offer what it is that you want. Does that
I
make
have
sense?
one question on that.
What's that?
I just had a quick question on that. So I have one. I'm assuming it doesn't matter if you adjust it on the fly as long as I'm not going over the agreed upon on the initial listing agreement. Like if my initial listing agreement was 4%, I'm actually the seller. And I did a 2%, 2%, but an agent negotiated a over asking offer. And we negotiated 2.5. I don't need to go back and adjust the listing agreement as long as I understand by accepting that I'm going to take 1.5 instead of 2.
That's correct. You can adjust that way. And you have to understand, guys, that what is going to be the Bible is what's in the contract for sale. Okay. So the commission that you're putting in the contract that and everyone signs off on is what is going to be what is upheld. Okay. Our contracts allow for that commission to be in there. The PA contracts do not. We had an agent get close to getting shafted on a PA deal because the contract is not, or I'm sorry, the commission's not in the contract. Ours do. So whatever it is that is agreed upon, make sure it's in the contract, and that is what the Bible is. Make sense, Ed?
Yes, thank you.
Okay.
Appreciate it.
Yes. Go ahead, Mark D.
Mark, can I? Yeah, thanks. So in the top of the listing agreement, we have 2% with zero going out for co-broker or
Right.
co-agent. Then in the bottom in the notes, we do say that we are open to negotiation. That would
Yeah.
be a proper way to write that. Yep.
Yeah, you
All right,
certainly
perfect.
can. You can put that in there as far as additional terms because what the rule is saying is that there can't be something that's open-ended. This is not open-ended as far as a commission. You actually have a finite number in a listing contract with Squata, and we're not offering anything. Okay. However, I'm putting in here that I am open to negotiations and tell our buyer to submit what they're asking for. But I do have a finite number in that contract being 0 or 1 or whatever it may be that you guys agree on.
Awesome. Thanks.
Good. Okay. And again, guys, there's not one thing in here that I'm telling you that you have to do. This is a business practice. You have to see what works best for your specific business practice. You have to have open discussions with your seller about how they want to do it and how it's going to be beneficial to them. All right. Okay. All right, moving on. Not going to go through seller duty, dual agency, designated agency. We talked about it, CIS, property condition disclosure. Again, there's got to be a property disclosure form that's in this packet as well. Inclusions and exclusions, guys. This is a pet peeve of mine. You need to be incredibly specific in the inclusions and exclusions. You cannot just leave something open to interpretation. It can't be all, appliances. Okay. What all does that mean? You got to be very specific. Washer, dryer, refrigerator in kitchen, exclusions, refrigerating garage, curtains in master bedroom, hot tub, play equipment. And I'm telling you, I've said this before, I had to write a cat into a contract. I wrote the cat into the contract that the cat was included and the sale of property because lucky the cat on Watsontown New Freedom Road was an outdoor cat and the people who were selling the property couldn't take it to the 55 plus community because they were only allowed one pet and they had a dog. So be very specific. Okay. Additional terms, if anything here applies, check off anything here that applies. All right, ownership and liens, not going through that for the sake of time. These here, as far as the laws, termination, breach. Let me touch on a couple things right here. Termination, seller, landlord agree and understand this agreement is a legally binding contract between seller and landlord and broker that may be terminated for legally sufficient cause or mutual agreement in writing. Has to be in writing, okay? If the seller, look guys, if the seller hates you, they don't like you, kill the deal and walk away. You're not going to have any kind of transaction that sticks together if the seller absolutely can't stand you. Sit down with them first, have a discussion with them, try and figure out why they don't like you and what happened, what went wrong, where you went wrong so you can learn a little bit and take it from there. But if a seller flat out doesn't like you and can't stand you, no reason to be in the contract. That's my feeling. If they don't like you, just move on. Okay. On the breach, if this agreement is an exclusive agreement and is not properly terminated and seller signs a broker service agreement concerning the property with another real estate broker's firm that becomes effective during the term of this agreement or that affects broker's rights during the protection period, seller will be in breach of this agreement. If seller breaches this agreement, the property subsequently under contract, sold, conveyed, leased, rented, optioned, or in any way transferred, broker will be entitled to pursue all remedies available, including but not limited to recovery of the commission set forth in this agreement. That means we got to sue if we want to collect the commission, okay? Which is not covered under E&O, just so you guys know. So, if you guys want to sue somebody, let me know. Let me know how much you want to pay for the attorney, okay? All right, moving on down. Additional terms. Talked about this. You can put whatever you want in here, guys. And yes, you can put some different negotiation tactics in here or different things that you and the seller agree on for commissions, okay? All right, everyone sign, everyone initial, moving on down. Lockbox, got to have them sign as far as lockbox if you're putting a super on or a combo lockbox. Not many people are using supers anymore, and it's because they are expensive, even though we still need to have the super key access that we need to pay the 17 bucks a month for just to make sure that those who do use supers, we can still get access to. But have them sign off on the lockbox authorization. All right, here's one of the new forms. I want to cover this real quick. This right here, check off up top, because you have to have this done for a seller and a buyer. This one, seller client. This talks about what Bright is. How does Bright work? Bright, this is a disclosure piece and a release of liability for them, essentially. Okay. And they're going to initial here acknowledgement of this. If you have a seller client, this is where you need to go through and address these. Okay. And this is how you're going to mark the property. Will your broker allow potential buyers, renters to learn a property? When? You put the date in here. That's the commencement date. Okay. And then go down here, how your broker use Bright. How are you going to do it? Use Bright to share my home's information with the open market. That is going to be yes, we're going to share it on the internet. Down here, no, we are not sharing it on the internet. Okay. Then you follow that down here. My home is ready for marketing, but will be ready for showings beginning on specific date. If it's coming soon, that is the date it is going live. If option 2C is selected, also circle one internet yes or no, which reflects back to A and B. That's why you're only doing 2C, even though it looks like you just have to do more. Okay. Well, here, this is for the exclusive. Don't want my home on the open market. Restrict marketing only to my broker's network. That needs to be initialed by the sellers. This is a required form. Okay.
Hey, Mark, really
Yep.
quick question. When this form came out, I remember when we did the session with the folks over at Bright. One of the things that they had said is for Section 2C, they were going to be working on some changes so that it was a little bit more flexible for .loop or DocuSign. It was supposed to be like a checkbox instead. I noticed that when I'm doing it via .loop, sometimes I forget that I have to circle one of those, like the internet yes or internet no. Have they given any update regarding like changes that they're planning on making to that section?
To my knowledge, no, we have not received any notification from them. No, but we will certainly
Okay.
check. Okay.
Okay, cool.
Check a note right here. Check on this. Okay. Got it. Thanks, Tim. All right, moving on. Lead-based paint. You guys got to get this signed and completed. Properties after January 1st, 1978. Got to get this, I'm sorry, prior. Get this done, signed, and initial. Check off whichever box applies, whether if they have knowledge, no knowledge, reports, no reports, and buyers receive 10-day opportunity or they're waiting. Okay. All right, the ABA. So the Alliance ABA, this is required right here. Form must be completed on every seller and buyer transaction, regardless if the client is working with Alliance or not. This is a RESPA compliance. We need this filled out, completed on every single loop that you're doing, whether if the deal closes or it does not close. If RESPA comes in and audits our files and we are missing this, then we are in trouble and we will get fined. This is just disclosing to them that Prime does have an interest in Alliance and essentially saying that if Alliance is utilized, Prime stands to make some money on that. Okay. That is a disclosure piece, and any corporation or any brokerage out there that has affiliated services will have this form done as well. Any questions on this form? Okay. Moving on. Wire fraud. Please have them sign this. Please, please, please have them sign this, guys. There's so much wire fraud that's going around, and emails are getting hacked, asking people to send wires without verification for anything. So please get this wire fraud form done. Please have a discussion with your clients. Do not ever wire money without consulting me first. Okay. It just happened to a title company 3 weeks ago, maybe, that I think it was like 70 or 80 grand was wired, and it was not to the title company. Okay. So please have the discussion with your clients. Do not ever send a wire without discussing anything with me, meaning you. Okay. All right. Disclosure form. Guys, if you have not seen or read the new disclosure form that came out, you need to. We sent it out to everyone. I think we have a post in the Facebook group, Heather, as well. And we did send an email to everyone with it. Get into Loop and review it. It is different. The questions are essentially all the same, or reviewed that, but how it's laid out is what's different. Okay. And again, this is required on every single deal, period. Okay. So you guys know how to go through and fill this out. Again, everything's got to be addressed on here. And I'm telling you, as far as to CYA and cover your butt, some investors like, well, I'm not signing anything. I'm not doing it. It's required. If it's an estate or something like that, they still need to address it to the best of their ability, and they can check off unknown for everything. Okay. If they don't know anything, just go through unknown for everything. But yes, it does need to be addressed. And I'll get to the bottom because I want to go over this with you guys too. Okay. So people always ask back and forth, should I sign? Should I not sign? Should I sign? Should I not sign? Okay. There are some people that say, no, we've been told not to sign. Others say, yes, we've been told to sign. I'm telling you guys that you should sign it. And here's why. Right here, seller's real estate broker confirms that he or she visually inspected the property with reasonable diligence to ascertain the accuracy of the information disclosed by the seller prior to providing a copy of the property disclosure statement to the buyer. If you don't sign that, and things go to crap, they go to court. Part of your job duty and your job description.
May I have name for order?
Kelly.
Right, let me get started for you.
Can I get a grande mocha, please? Mute yourself. Oh, Lord.
I gotta mute myself.
Get
All
on
right,
mute.
I thought I was muted.
Get on mute. Stop talking. All right. Part of your job, guys, is to do this. Okay. And if it goes to court or it gets in attorney's hands, they're going to ask you, did you do this? And you may say yes. Okay. Well, there's no written evidence, there's no written proof that you did. You need to do that, and that wouldn't go well. As far as a buyer's agent goes, all it says that you got a copy, and that's it. So don't stress about that. Okay. You acknowledge receipt of the property disclosure statement form for the purpose of providing it to the prospective buyer. That's all that says. Okay. And yes, it is your job to make sure you get a copy of that disclosure form and get it to your buyer. Now, there is some misinformation going around saying that if there's no seller property disclosure form, the contract is not a contract. That is not accurate, guys. The contract is a contract when it is executed and signed by all parties and out of attorney review. If the seller property disclosure form is not obtained, it is not a reason to sit there and walk away from the contract. It's going to come back on you and say, okay, your job was to make sure you get a copy of that seller property disclosure form, get it to your client. You didn't do it. It's going to go on the buyer. You're supposed to get a copy. It's going to the seller. You're supposed to provide a copy. It doesn't mean the contract is null and void if you don't get a copy. It is your job as the buyer's agent to get a copy of it, and as your job as the listing agent, make sure you provide a copy to the other party. Okay? Okay. Down here.
Can I ask?
Yeah, go ahead.
I just want to ask two questions. Sorry to keep jumping in.
Yeah.
So I've noticed a couple of instances where like it's an estate and the executor, like they don't fill out the disclosure at all. They just sign the disclosure and they're just going off the bat that they don't know anything about the property. They're not checking unknown. They're not checking anything.
Right.
Is that, if we're bringing the buyer, is that our responsibility to kind of like, get them to fill it out at that point?
Not your responsibility to get it filled out, but what is a solution that you can think of that would protect you and cover your butt? So
I don't know.
you're talking as the buyer's agent, correct?
Yep.
Okay, so if I get that and I'm the buyer's agent, I'm going to speak to the listing agent and say, hey, look, I got a copy of the disclosure form and there's nothing's filled out. What's going on? Listing agent's going to tell me, well, it's an estate, seller doesn't know anything, so that's the best that he can do. That's all that the seller agrees to do. I'm then going to follow up that conversation with an email to the agent. Mr. and Mrs. Listing Agent, summarize our conversation. As you know, the seller property disclosure form is a requirement by law in the state of New Jersey. Based on our conversation, you're telling me that the seller property disclosure form that I have received is all the seller is willing to do and all the information the seller is willing to provide, correct? Correct. Then now you have at least a paper trail there that you have done your diligence and you've done your duty to try and obtain more information.
Okay, cool.
Okay.
And then the second part to that, I still see like some flips where investors are also doing the same.
Mm-hmm.
They're just saying that they've never lived in the property, even though they've completely renovated
Right.
the thing and probably know it better than anyone else.
Right.
Same thing.
Same thing. So it's going to be Mr. Listing Agent, Mrs. Listing Agent. Based on our conversation, to summarize our conversation, I'm in receipt of the seller property disclosure form, and based on the seller property disclosure form, the investor who has done the renovation of the property is not willing to disclose the renovations that they have done to the property. Correct?
Okay, cool. Awesome. Thank you.
Okay. Okay, this is all part of the seller disclosure form. Again, it's going through it. The flood part, that's got to be done, and the solar applies if they're solar. So go through that and get that done as well. Okay. Seller's title order form. If Alliance is going to do seller processing, got to get the below forms filled out, and that is us and our proof in writing that the seller has granted Alliance the authorization to conduct the seller processing for the transaction. Okay.
Can you go back up? Is this the one I think that, please no, right back down. Go back down again. Right here towards the bottom. Everyone, just a heads up that this does have to be a wet signature. You cannot send this out via DocuSign. So you have to like, I normally leave a copy with them, or I have them sign it when I'm meeting for the listing appointment. Because it's one less thing that you're going to have to do once you get under contract, because they won't accept an electronic signature.
And guys, understand that's from the mortgage companies that the payoff is going to be obtained from. That's not the Alliance thing. The mortgage company is going to want the wet signature on it. Okay. Thanks, Heather. Last one, as far as when any of the status changes below apply here, forms got to be done and signed. Okay, price change, extension, back to active, other changes, and then also if it goes temporarily off the market, canceled, or withdrawn. So if any of these changes are going to apply, you need to get this form done and signed. I can tell you right now, guys, I checked yesterday, and this new one is not in dot loop coded for it to be fillable. Sarah's going to work on that to check and get that done. But for whatever reason, the state library forms has the old listing change form in there. Okay, so we'll get this done and taken care of. Okay. This is the listing packet. These are the listing docs. Any questions on this before I move on to the buyer side? Okay, moving on. Next. All right, here we go. Up to the top. A lot of similarities as far as some of the forms, guys. All right, CIS. Okay, again, difference here. Buyer's agent, dual agent, and designated agency. The CIS, the same exact form. Nothing changes whether if you're using it for a buyer or for a seller. Just who signs. Okay. Consent to dual. So when you're getting all of your buyer docs signed by the buyer, yes, you want to talk to them about dual agency. You want to talk to them about designated agency and what they would like and what they would prefer. Okay. On whichever one applies, have them sign and make sure you get the consent. This form is required. You'll see that in our checklist in Loop as far as the forms that are required. Okay. Designated agency, again, we just went through that on the seller side. Same thing. All right. Buyer agency contract. There we go. All right. By the way, you like my names of my buyers? I do like the names of the buyers. I got Frankie and Dean. Okay. So Frankie and Dean are my buyers. I'm the agent. Okay. This part right here, guys, I mean, just leave blank. I mean, they may be looking all over the place. You can put in specific towns, counties, whatever it is, but if you want to leave it blank so it covers everything, just leave it blank. Okay. And it says in there, you don't have to write in all of New Jersey because if you read, if no municipalities or counties are filled in, then the area shall be New Jersey. So you don't have to do that. If it's blank, it's New Jersey. Okay. Buyer's representation. Buyer does not have a business relationship with another real estate brokerage firm. So here I want you to see there's two differences on this form and the non-exclusive buyer agency. Now, if you're talking about non-exclusive buyer agency, guys, that's your call. I do not have a problem with you guys doing a non-exclusive buyer agency contract. Okay, there is a non-exclusive in the MLS. I'm sorry, in .loop. The difference here is that buyer does not have an exclusive business relationship with another real estate brokerage firm. You cannot have a non-exclusive buyer agency contract signed with a client that has an exclusive buyer agency contract signed with another firm. Okay. But if you choose to do that as far as your business practice, and if that's part of what gets you in the door and gets that relationship going, is that look, when I have the buyer agency contract signed, we can do a non-exclusive. You can use whoever you want, and it's your job to earn the trust and flip that to an exclusive. Make sense? Okay. Going down here as far as agency disclosure, again, you're going to check off whichever one applies when you have that discussion with them to the term. Yes, you need a start date and an end date. Okay. You need a start date and an end date for the buyer agency contract. And I deal with these questions all the time, guys. People call and say, hey, look, I spoke to a buyer. They did sign a contract with another agent. They do not like the other agent and want to work with me. What is the process? Right here. Okay. Or 3 days after broker or buyer receives a written termination notice from the other party. Okay. So if your buyer wants to terminate a contract with another agent, they need to send written notice to their agent that thank you very much for being a crappy agent. I'm going to move on and I effectively terminate our relationship here. And then that will be effective 3 days from it being sent, not being received, because not every agent checks their emails. Or a Facebook group, I might add. Okay. So that is upon being sent, effective upon being sent. All right. All right. Commissioner broker, again, the disclosures have to be in there for law. Commission from, we do not do retainers, guys. There are specific reasons we don't do retainers. One, it's a fucking accounting nightmare and a pain in the ass, and I have enough accounting shit that I need to do in here. So I don't want any more. We're not doing any retainers. Get paid a commission. Whatever commission that you agree to with your client will go here. Okay, as far as a percent of the purchase price, flat fee, whatever it may be. Okay, right here, again, it can't be open ended. Okay, as far as what you're going to charge the buyer, there has to be a number in there. And yes, guys, we have plenty of agents here that will go to closing because they put a certain percentage up here and the seller is not offering that, and the buyer has to make up the difference. So we'll go to closing, and the buyer will be bringing a check, and there's also a check paid from the title company from the seller's proceeds. Okay? It happens. Yes, it's all based on discussion that you have, the relationship that you have. Okay? Make sense? Okay. All right. Right here, as far as buyer's commission earned, due, and payable. Here's the deal, guys. You're going to get a commission when you close on the property. Okay. I have been to the board a few times for procuring cause, and I can tell you this: who the fuck knows what's going to happen? No idea what's going to happen. I think it's all based on how the panelists are feeling that day, who they like and who they don't like, and I'm telling you that is my absolute honest to God opinion on that. So there's nothing that's going to be black and white that's here. You can read this and interpret it however you want it, but I'm telling you, with procuring cause, who knows what's going to happen? You'll get paid a commission when you close. Okay. Protection period right here, same thing. Okay. You put in whatever amount of days that you want there, that there is a protection period as well in this contract. But again, you have to give notice of the properties that you took that buyer into. So if your buyer terminates the contract with you, what you need to do is send a notice to the buyer that, okay, recognize the cancellation of this agreement effective 3 days from now. However, here are the properties that I took you into, or properties I took you into, made offers on. If you purchase one of those properties within 30 days after this contract terminates, you will be due a commission to me. And that is the buyer. That's not the other brokerage, the listing brokerage. Okay. Okay. All right, commission from the seller right here. If seller authorizes payment of commission to any broker, that amount will be credited towards the commission due to broker under this agreement. If the amount of broker's commission from any source, including any offer of a commission from seller, listing broker, buyer, exceeds the commission buyer has agreed to pay broker, then the excess will be credited to buyer unless otherwise agreed to by the parties in writing. Okay? You understand? So if you put 2% in here and you're being paid out 3%, read that. Does that make sense, guys? As far as what you get, that extra percent will be credited to the buyer, unless you work with the buyer to change that. But understand that's how it goes. This was put in place so agents don't go in and undercut themselves all the time. And you go in and say, look, just to sign a buyer agency contract with me, I'm going to charge you $1, charge you $1. Because if you're charging $1 and then the seller is paying a 2.5%, you're getting $1. You get $1, and that's it. So don't slice yourself out and cut yourself low on that, because it'll come back to bite you. Okay? All right. If sellers often pay broker an amount less than commission buyers agree to pay broker, buyer directs broker to do the following. Check all apply. Include any offer to seller that will pay the broker's commission. So you can put it in any offer, right? Your buyer, you may be charging your buyer 2%, 2.5%, 3%, 4%, 5%, 6%, whatever percent that you're charging that buyer in this agreement, but you can still submit in any offer what you want the seller to pay. Okay? And if the seller agrees to pay less than what you agree on, okay, buyer comes up with a difference. Now, if your buyer doesn't have the money to, guys, you can negotiate how you want. You can alter this, you can change that, you can amend the buyer entry agreement that I agree to only take X percent. You can certainly do that if you don't want to hit the money, the buyer up for extra money. But I'm telling you that we come to closing, people go to closing plenty of times, the buyer's bringing the difference. It happens all the time. Make sense? Okay. Moving along. Broker's duty, buyer duty. Other buyers, read it. Oh, other buyers, real quick, guys. So you understand too that if you were showing the same house to multiple buyers, you're a dual agent. Okay. You're a dual agent if you're showing the house to the same property to two different buyers. And you go through this in any such a situation, broker shall maintain confidentiality and will not disclose to any other potential buyer the terms of buyer's offer or any other confidential information concerning buyer. Sounds exactly like dual agency, doesn't it? It's because it is. Okay. So yes, you can be a dual agent if you're showing two different buyers, one single property. Dual agency, designated agency. Went through it. Plenty. Guys, understand this. Read through this. Same thing as far as the termination and the breach and any different terms you guys want to put in here, you can put in here. Now, one thing that you can put in here as far as the buyer's agent contract, you can make it for specific properties. Okay. If you're going into 123 Main and you're asking the buyer to sign a contract for 30 days, 60 days, 90 days, and they're like, hey, I just met you. I'm not comfortable doing that. Look, I get it, but you can terminate it if you send me a written notice. Or look, we're going to make this specific to this property, specific to this property, specific to 123 Main. If you buy something else, do anything else, this agreement does not apply. Okay, does not apply. So you can certainly write that in here under paragraph 17. Any questions on that, guys? Okay, moving on. I think I'm moving on. All right, get it signed. All parties sign that. Move along here. Non-exclusive buyer agency, guys, pretty much the same exact as the buyer agency, but it is non-exclusive. Okay. So again, I don't have an issue with you guys doing that. If you want to do that, it's your business, your call. The objective, I can tell you that if you do make it a non-exclusive, your objective will be to flip that to an exclusive buyer agency contract. And then once you get the rapport, that relationship established, and you establish your value proposition. Okay. The greater the value proposition that you have with your clients, the easier it's going to be for them to stay with you, sign the agency contract, and follow your advice in the entire transaction and make your world a lot easier. Okay. So I'm not going to go through the whole thing. Same exact thing. Again, don't do retainers. Moving right along on this. No questions on that. All right. MLS disclosure. We went through it on the seller side. Here it is on the buyer side. All you need on this, on the buyer side, and yes, it's required for seller and buyer. You will check off buyer client here, and they will initial here that they acknowledge and understand the above disclosures from the MLS. They do not need to do anything here because they are not a seller. Okay? So on the buyer side, check off buyer, and they initial here. And finito. That's it. All right? Same thing with Alliance, okay? Form must be completed on all buyer and seller transactions, regardless if the client is working with Alliance, which they should, because Alliance is fucking awesome. And Aaron and her team do an amazing job. But this is a RESPA requirement. So again, we do need to have this signed on every single one. Wire fraud, again, especially so important on the buyer side. Do tell your client, do not ever wire money without talking to me first. They will get emails that is masked as the title company. It will go to their email and they will request a wire. And people have lost hundreds and hundreds of thousands of dollars, guys, doing this, and it's not going to come back. Okay? Have them sign that. Do not ever send a wire without discussing it with you first. Inspection waiver. Now, if someone's going to waive inspections, okay, again, don't recommend it at all to ever waive inspections. If buyer's going to waive inspections, don't ever recommend. Buyer needs to sign this form. I know there's one in .loop. It's a little different and a little more convoluted as far as that inspection waiver. I do like this, and I do prefer this one. This is in .loop, that everyone's being held harmless, not liable, and everyone's acknowledging on there that we have told them to get inspections, but they're going to waive it anyway and have them sign off on this. Okay. All right. Proposal purchase. I'm not going to go through the proposal on how to do one. There is a video on the YouTube channel on how to do one, but this is the proposal purchase form, which is in .loop. And then a commission statement. Guys, so commission statement needs to be done on every single deal that you have. Do you guys know why? Does someone know why? Someone please tell me why a commission statement needs to be done on every single transaction.
Well, it has your signature on it, so that's kind of the first one.
But not the main reason.
I mean, tracking for the bridge.
It's a bill.
Like obvious one.
It's a bill, guys. So any bill and invoice that's being paid, anything as far as a payment on the settlement statement, you do need an invoice and a bill for it. So that's why the title company needs the commission statement. Okay. Plus, in addition to as well, that if you're, you work on the buyer side and you got a house and the commission is being paid and your buyer's paying for some of it too, title needs to know, everyone needs to know, mortgage company needs to know as far as where money's coming from. So you know that in this situation here, 15 grand is being paid for by the seller. Then you got another 3 grand being paid for by the buyer. Okay, so that delineates specifically so the title company knows and they can account for it properly on the closing statement who's paying what commission and how much and who it's going to. Okay. And then down here, guys, I will tell you, yes, we do prefer for commission to be wired in. When you guys close at Alliance, Alliance is connected to our account. They just transfer the money over to us when closing's done and they disperse. Money comes right out to you. If you're at a different title company, yes, we do prefer to have the commission wired in to save you guys time so you don't have to worry about running around all over the place getting checks in, meeting timelines to get checks in, whether you get a check in today, you get it in tomorrow. If I'm not here, if I am here, Sarah's here, not here, whatever it may be. But yeah, try and get the commission wired in, make your life a lot easier. Now, we will never send you guys wiring instructions. I'm not sending wire instructions out to everyone to our bank account. Sarah coordinates all wires. If Sarah is not available, I will take care of it. But it is Sarah, if you're doing a wire at a closing at a different title company, have the closer coordinate the wire with Sarah and she will take care of it because there is a specific protocol and process that we have in play to make sure the wiring instructions are going to who they need to go to. Okay. Thank you. Next. All right. I will give you this here, guys. When you're at closing, whether you're on the listing side or buyer side, get a final walkthrough form done. Okay. Get a final walkthrough form done that the buyer signs off on, that they have walked through and reviewed the property prior to closing on, or buyers elected not to walk through the property prior to closing on. You need to have this done, guys. It will save you if it goes to a lawsuit. Okay. And I can specifically tell you, there are reasons that I learned these things too. I can specifically tell you if you get brought into a lawsuit for something that the buyer is not happy about after closing, if you do not have this form signed in some way, it will hurt you. It will hurt you. Okay. Go through, do the walkthrough prior to closing. If they accept the property, cool, check it off. If there's something that say, hey, look, I walked through, I'm not happy with this, I'm not happy with that, write it on here. Write it on here, type it on here, have the buyer initial it, do something. This covers you and protects you as an agent. Get this signed and done on every single transaction. Okay. Well, damn, guys, I wanted to keep it to about an hour, and we're 2 minutes shy of that. So that's awesome. Open it up to questions, guys. Any questions? Listing packet, buyer packet, anything about these documents, the packet that has to be together, legalities behind it, how to fill something out, strategies. Fire away. Let me know if anyone's got anything. No? Okay. You're all liars.
I'm good. I'm good. You answered all the questions in real time. I'm good to
go. All right. When I stop this, guys, I am going to, again, it's been recorded. I will convert this to a video to get it out there. It's going to take a while because it's a long video, but I'll get this out there. I'll recirculate it back in the Facebook group. We'll have it on the YouTube channel. Please revert back to this. And here's the last thing I stress to all of you. Please do not try and fake it till you make it with the legal documents. Okay. With these legal documents, do not fake it till you make it. If there are any questions whatsoever, call me, call Sarah, call Heather, call Rob. Ask the question, get it, and we will answer it for you. Okay. But do not fake it till you make it. This is not the time to do that. All right. I appreciate you all for being on. Thank you very much for taking the time. Let me stop my share. Again, I'll get this converted to the YouTube video as soon as I figure out how to stop the recording, and we'll get it out to everyone. So thank you all for taking the time today. I will see you guys later.
Yeah.
Bye, guys.
Thank you.
You're welcome.